Hi, everyone. We have two scholars who have been studying different aspects of the globalization of fair use rules. So first, we're going to have a presentation by Peter Yu. Peter Yu is the Regents Professor of Law and Communication and Director of the Center of Law and Intellectual Property at Texas A&M University. One of his most important items in his long list of biographical references is that he serves as the co-chair with me of the International Intellectual Property Committee of the American branch of the International Law Association. And Peter will talk about how fair use has globalized and changes as it goes in a number of different countries. So Peter, welcome. It's good to have you. Over to you.
Thank you, Sean. It's a pleasure to be here. Niva, it's good to see you as well. So the topic I have for today is about how different countries have customized fair use when they're transplanting the provisions into their jurisdictions. This presentation, as well as some of the articles I've written in this area, are based on a lot of the interactions I've had with different jurisdictions, especially in Hong Kong, where I've been helping with copyright reform in the last round of the copyright reform. So when we think about fair use, we can see that there are a lot of different jurisdictions that have either considered adopting fair use or they've already adopted fair use or something similar to the provisions there, even though they may call it somewhat differently, like fair dealing. So here on the slides, you can see that there are different jurisdictions that are quite involved, and some of these jurisdictions will come up in this presentation. So the starting point when we talk about legal transplants, we always go to the book written by Alan Watson, which is a seminal work on legal transplant. There are a lot of works in the legal literature covering the development of legal transplants, both in favor of it and also criticizing it. So there are different benefits of having legal transplants. The first one is that you can actually free ride on the legislative efforts of other jurisdictions. You don't need to reinvent the wheel every single time. Another benefit is that you can introduce laws that have been already well tested from other countries, and you're not doing the experiment for the first time. A third benefit is that you can draw on lessons from foreign countries. So if other countries have already experienced some problems or they need to make adjustment, you can take advantage of those lessons. The fourth benefit is that you can actually provide a preemptive defense so that you don't need to worry about actions taken by other governments. For example, the Section 301 process in the United States or a similar process in the European Union. And the idea is that if we transplant laws from those other jurisdictions, it's much harder for those other jurisdictions to complain about the laws that you have introduced in your jurisdiction. And the last benefit is obviously it facilitates international harmonization because a lot of other countries, if they are embracing similar legislation, then you promote international harmonization. So those are different benefits of legal transplants, and this will apply in the copyright area as well as on fair use. But there are also drawbacks of having legal transplants. For example, when the transplant is not suitable, it can stifle local development. And so this is a major concern, I think, for a lot of creators as well as communities in different countries about how it will affect the local development. It can also upset local tradition. A good example would be a lot of countries that do not get used to having the legal transplant may have to adjust the legal system, the regulatory system, in light of the new provisions that have been brought into your jurisdiction. A third drawback is that you can reduce opportunities for experiments. The benefits, as I mentioned earlier on, is that you have international harmonization. The drawback is that if everybody has similar laws, you also don't have as much opportunity for you to do experiments. And the fourth drawback of legal transplant is that if there are problems in other countries, you may import problems into your own country. You can still learn the lessons from them, but at the same time, you need to deal with the problems first. And the last one is basically, if you transplant laws from other countries, it doesn't fit very well with the local conditions. It might not be as effective as you find in other jurisdictions. So here on the slides, you can also see that there are a lot of drawbacks with respect to legal transplant. So when we think about whether to actually transplant laws from other countries, we need to keep in mind both the benefits and also the drawbacks of legal transplant. And the recommendation I always have is that focus on local conditions and customize the laws, then you can take advantage of the benefits and you can also reduce the drawbacks from legal transplant. So what I'm going to show you is different modalities of transplantation, different ways jurisdictions bring into their country's fair use legislation. So there are 8 different modalities I'm going to cover. So the first one is pretty easy. You can just introduce a verbatim transplant. You don't need to change anything. In Sierra Leone, you basically have the provision that is basically identical to Section 107 of the Corporate Statute, and there's a fair use provision. There's a minor modification. For example, toward the end, you see something about computer programs, but this is basically virtually identical. Another example here is in Malaysia. So Section 13 right here includes similar wording coming from the fair use provision in the US. The second modality is about how you can actually add the 3-step test that comes from the Berne Convention, the TRIPS Agreement, and also the WIPO Copyright Treaty. And so if you go to South Korea, you can see that the 3-step test has been incorporated into Section 35 here. The important takeaway is that because the fair use provision usually talk about the limited purpose, a lot of the transplant of the 3-step test actually include only the last 2 steps, but not the first step. So this is basically the inclusion of 2 steps of the 3-step test in the provision. A third modality is that you can add a regulatory authority. So the example I use right here from Israel, you can see that you can include a provision saying that the minister may make regulations prescribing conditions under use shall be deemed a fair use. And so I think this is a very good example of how you can actually bring in additional authority outside the fair use provision. Obviously, Niva is here with us. I'll let her speak about this particular provision. The fourth modality is about adding deference to a side agreement. And so the example I have here is Taiwan, where the corporate owner organization and the exploiter organization have formed an agreement on the scope of the fair use of a work. It may be taken as a reference in the determination referred to in the preceding paragraph. So there's an outside process that will develop an agreement for the different parties that might be involved in the corporate system, and the court will take into account that side agreement. This is an approach that is quite common in a lot of jurisdictions. For example, in Australia, they will incorporate the code of practice so that they will be able to develop some of the additional norms outside the corporate system, not through the legislature, but also through other negotiation process. The fifth modality is how we can actually mix the legal transplant with fair dealing. So a lot of the jurisdictions I mentioned here initially have the fair dealing system, and it's important for them to think about how to make adjustment. And one way to do it is to make the legal transplant of fair use together with what they currently have. So the example I have here is Singapore, where you have Section 35 that is about fair dealing in relation to work. And here you can see that even though the provision is called fair dealing, but the language included in Section 35 is basically similar to what we have in Section 107 of the US corporate system. This provision was adopted after the negotiation of the US-Singapore Free Trade Agreement. But for comparison purposes, you can look at the other provisions here. Those are the traditional fair dealing provisions we have in Commonwealth jurisdictions. So what we got here is a mixture of both the fair use language as well as the traditional fair dealing provisions that we find in the Commonwealth jurisdictions. Another example is what we get in Sri Lanka. So here you also have provisions saying that the acts of fair use shall include the circumstances specified in Section 12, and Section 12 is the fair dealing provision that is included in the statute before incorporation of fair use. The sixth modality is about how we can require the priority consideration of fair dealing. And the example I want to show you here is from Ireland. So about a decade ago, the Corporate Review Committee in Ireland provided a consultation report, and here they some of the proposal they include is that the court shall not consider whether a use constitutes a fair use without first considering whether that use amounts to another act permitted by this part. And so the committee believes that it's a good way to incorporate this idea into the statute, but at the same time, without making wholesale changes to the current system. So that's a very good example. The seventh modality is about how we can actually include an illustrative list of the different fair use provision. And this is also a proposal, but not incorporated in the current statute. That's from the Australian Law Review Commission. And what the Australian Law Reform Commission proposed in a recommendation is that we can actually include a non-exhaustive list of illustrative uses and purposes for those of who are trying to understand what type of users will qualify. They can always look at the list. And so here on the slide right here, the list includes a lot of things we normally find in fair use and fair dealing provisions, research or study, criticism, parody, reporting news, etc. So this is a very good example to show that there are different possibilities of fitting within the limitation exception, and those are drawn from legislation from different jurisdictions. As I mentioned earlier on, there's also a report from the Corporate Review Committee from Ireland. They have also a similar proposal. The other acts permitted by this part shall be regarded as examples of fair use. So this is somewhat similar to Sri Lanka, and what they're doing is to show the different examples of fair use based on the limitations exceptions that are already in the statute. And the eighth modality is add a general saving clause. And the example I have here is the proposal we advanced in Hong Kong when we were considering corporate reform in the last round of corporate reform, and not the current round. So one idea is that since there are different fair dealing provisions already in the statute, and the government has also proposed some of the fair dealing provisions, what we want to do is basically include a fair use as a catch-all general saving clause, so that anything that does not fit within the different fair dealing arrangements, it will go into a general saving clause. So that's a very good way to introduce fair use without changing the existing legislation. And we can also take advantage of the legislation similar to how I shown earlier that some jurisdictions actually mix together fair dealing and fair use. Another example is the recently adopted legislation in the Third Amendment to the Chinese Copyright Law. And here, included at the very bottom is a provision saying that other circumstances as provided by laws and administrative regulations. And so this is similar to the catch-all, except that those circumstances will only be considered when it has been provided by laws and administrative regulations. So to the extent that the laws and regulations have not been adopted, those circumstances will not be recognized yet. What I want to end on in this presentation is the different lessons we can draw from looking at the different modalities of transplanting fair use in different jurisdictions. So I'm going to share with you 5 different lessons, which I hope will be useful and which I hope will actually spark some discussion later on. The first one is that we can have good transplant and we can have bad transplant. Some people will look at fair use as a good transplant and the DMCA, especially provisions like the anti-circumvention provision, as a bad transplant. But if depending on perspective, you can also look at it differently. I think the takeaway here is not so much to categorize some legislation as a good transplant or bad transplant, but important takeaway here is to understand that there are transplants that are good and they are bad, and it's very important for countries to actually think about what type of transplants they want to consider and adopt. The second lesson is what I mentioned earlier on. It's very important to customize the legal transplants when you're going to introduce new legislation. It might not fare very well with the local conditions, or it might upset the local traditions. So it's very important to actually customize the transplanted laws you have so that it fits better with the local conditions. That way, you can maximize the benefits, but you can also reduce the negative effects on the local jurisdiction. The third lesson we can draw from legal transplant is actually taken from the book written by Andrew Watson, which I mentioned earlier on. The time of reception is often a time when the provision is looked at closely, hence a time when law can be reformed or made more sophisticated. It's important to understand that when we are doing legal transplants, we can actually undertake experiment, we can undertake reform, and we can make the law better. That's part of the customization process I mentioned earlier on, but it's important to show that one, we can actually make adjustments so that the law can be better. And two, if we're going to make the law better, other jurisdictions that can also learn something from it. So a good example would be if law is transplanted from US, but it has been adjusted in other jurisdictions, US can also benefit from lessons from those other jurisdictions. The fourth lesson is to understand that when we are trying to convert the law from fair dealing to fair use, there are different entry points. You can actually have legal reform. So you have to look at the development of fair use and fair dealing as a spectrum. You can come in at different points. If you want to make the law closer to fair use, go to the far left. If you wanted to make it closer to fair dealing, go to the far right. If you want to have somewhat in between, go to the middle. And a lot of the jurisdictions I mentioned basically introduce laws that are closer to a hybrid between fair use and fair dealing, and it's entirely up to the legislature to actually figure out what would be the most ideal arrangement for a jurisdiction. And so we should not always assume that fair use or fair dealing is a binary choice. They need to decide whether they go on the left or they go on the right, but it can be somewhere in between. We can talk about paradigm shift if we're going to move from, for example, fair dealing to fair use. But a lot of times we are basically looking at something what I would describe as the paradigm evolution. You have the fair dealing provision, but you can make changes by mixing fair dealing with fair use or introducing additional authority or referring to a code of practice. There are different ways you can change the paradigm, but it's not always a shift. You can actually evolve the paradigm so that it incorporates different elements. You can improve on it. You can take advantage of the different features in the fair use regime while retaining what you like about the status quo. So there are different ways you can do it. So in the interest of time, I'll stop here, and then I hope we'll have more discussion. Now, let me pass it back to Sean Flynn.
Thank you for that super overview of some of the more kind of general concerns and even recommendations on adopting fair use systems within local law, whether those be civil law type systems like the China example, or some of the adopting from fair dealing to fair use, so opening the lists of purposes in UK derived kind of Commonwealth style exceptions, which are some of the other examples.